Chapter 3: Equal Employment and Human Resource Management by Ashley Bell. Introduction. Equal employment opportunity, also known as EEO, is the treatment of individuals in all aspects of employment, hiring, promotion, training, etc., in a fair and non-biased manner. Equal Employment Opportunity Commission, the EEOC. The EEOC work consists of formulating EEO policy and approving all litigation involved in maintaining equal employment opportunity. The EEOC guidelines are not federal law but administrative guidelines. 3.1 Historical Perspectives of EEO Legislation. In 1866, the Civil Rights Act gave right to enjoy full benefits of the law, regardless of race. Then in 1933, the Unemployment Relief Act prohibited employment discrimination based off of race, color, or religious beliefs. And then in 1941, Executive Order 8801 by Franklin D. Roosevelt ensured American citizens would be guaranteed equal employment opportunities from factories awarded World War II defense contracts. 3.2 Government Regulation of EEO. Early laws and regulations laid ground for new provisions that have been passed to prevent discrimination. Major federal laws have been put into place to protect minority groups which are most affected by unfair unemployment practices. These people are known as the protected classes. Individuals of a minority race, women, older people, and those with disabilities are covered by the federal laws on EEO. Government regulation of EEO continued. The bona fide occupational qualification is one exception to the standards of unethical employment practices. The bona fide occupational qualification is suitable defense against discrimination charges only when age, religion, sex, or national origin is an actual qualification for performing the job. Business necessity. A practice that is necessary to the safe and efficient operation of an organization. And reasonable accommodation. An attempt by employers to adjust without undue hardship the working conditions or schedules of employees with disabilities or religious preferences. Here are some of the most important laws that have been put into place regarding unfair employment standards, such as the Equal Pay Act of 1963, which requires all employers required by the Fair Labor Standards Act and others to provide equal pay for equal work, regardless of sex. Then the Civil Rights Act of 1964 prohibits discrimination in employment on basis of old age, color, religion, sex, or national origin, which was created by the EEOC. The Equal Employment and Opportunity Act strengthened the EEOC's enforcement powers and it extends coverage of Title VII to government employees, employees of higher education, their employers, and employees. Other EEO legislation issues. Sexual harassment is one of them, which is unwelcome advances, requests for sexual favors, and other verbal or physical conduct of a sexual nature in the working environment. Discrimination due to sexual orientation. Immigration Reform and Control, which prohibits employers from knowingly hiring or retaining unauthorized. Other EEO issues, such as physical traits and discrimination against weight and attractiveness, and discrimination against caregivers such as single parents. 3.4. Uniform Guidelines on Employee Selection Procedures. A procedural document published in the Federal Register to help employers comply with federal regulations against discriminatory actions. Validity. Employers must be able to prove that their selection process has a direct relationship to the success of the job. Adverse impact. Concept that refers to the rejection of a significantly higher percentage of a protected class compared to that of an unprotected class. Disparate treatment. Situation in which protected class members receive unequal treatment or are evaluated by different standards. The 4/5 rule is a general rule of thumb followed by the EEOC in determining adverse impact for use in enforcement proceedings. Restricted policy. Evidence that the employer has an election process that would exclude members of a protected class, intentional or not. Then workforce utilization analysis. The process of classifying protected class members by number and by the type of job they hold within the organization. 3.5. Enforcing EEO legislation. Ways to enforce EEO legislation is record keeping and posting requirements, processing discrimination charges. Employees or job applicants who believe they have been discriminated against must fill out a charge form. A charge form is a discrimination complaint filled with the EEOC by employees or job applicants, and this process must be done within 180 days. Then the last thing is employers must not retaliate. Demotion, termination, and unjust negative appraisals, more supervision, reducing pay or responsibilities, or transferring to a less desirable job are some ways that employers may retaliate. These are the basic steps of filing a charge of employment discrimination. It starts with the charge being filed, an EEOC investigation, where they may find reasonable cause, and if so, this could actually go to the federal district court. 3.6. Affirmative action and diversity management. Affirmative action is a policy that goes beyond equal employment opportunity by requiring organizations to comply with the law and correct any past discriminatory actions. Reverse discrimination. The act of giving preference to members of protected classes to the extent that unprotected individuals believe they are suffering discrimination. Oftentimes, a chief diversity officer is hired, which is a top executive responsible for implementing a firm's diversity efforts. References. Managing Human Resources, 18th edition by Nell A. Scott.